Hello, everyone. It's good to be with you today. Sorry I can't be there with you in person, but I very much appreciate the opportunity to be here virtually. My name is Alyssa John. I'm with the Center for Climate Integrity, and it's really a privilege to be here and be part of this conversation and dialogue on climate change litigation in Indonesia. I have been asked to give a brief overview of climate litigation in the United States, which is a difficult task considering that there's an incredible breadth of litigation that has been tested here in the US and hundreds, possibly thousands of cases that might qualify as climate change litigation. Being brought under various statutes and common law theories, causes of action, uh, and more procedural requirements and regulations. And I wanted to just give a very brief summary of the different categories and types of actions that are being brought, and then also share two case studies of two of the leading cases and types of litigation that we're seeing here in the US. So before I launch into the types of actions that we're seeing in the US, I just wanted to reference the Columbia Law School Center, the Sabin Center, which I'm guessing many of you might be familiar with already, but it's an excellent resource. They have an incredible database of both US and non-US litigation efforts that are underway. And it really provides a very detailed summary of each of these cases, and they've provided a number of reports and analyses that can support you in your work and in learning more. So I recommend that you check them out at climatecasechart.com. And with that, I wanted to talk about and break things down a little bit into categories and explain the types of legal actions that we're seeing in the U.S. Obviously, there are many efforts underway to hold governmental and corporate actors accountable for climate change. And in my mind, I've broken them down into mitigation, adaptation, monitoring and reporting and assessment of impacts as one category, and rights and liabilities. And I think much of the action that we've seen has been related to mitigation. There are a lot of actions underway to prevent or limit the funding or authorization of a source of greenhouse gas emissions. So that could be efforts to prevent the building, funding, or permitting of a coal power plant. There are a number of actions to overturn decisions that have refused to place limits on proposals to carry out, fund, or authorize those same types of emissions. So once a permit has been approved, or any type of authorization by a government agency, there's a lot of efforts to challenge those decisions. So any kind of infrastructure, coal power plants, offshore oil development, anytime a permit is granted, we are on the front lines trying to challenge those decisions. There are a number of actions that have been taken both at the federal and state level to require the legislature or a government agency to write a statute or rule or policy establishing more stringent limits on greenhouse gas emissions through regulation. So one of the ways that we've done that is through the Environmental Protection Agency, which initially refused to regulate greenhouse gas emissions. And there was a landmark case called Massachusetts v. EPA that basically said that no, carbon dioxide is in fact a pollutant that does need to be regulated. That pretty much sums up the types of actions we're seeing on the mitigation front. On adaptation, there are far fewer cases involving adaptation. Many of the cases that have been brought haven't been successful. But the more recent trend that we're seeing are actions to hold corporate actors, and specifically the fossil fuel companies, major fossil fuel companies, accountable for climate damages. And I'll speak about that in a bit more detail as one of the case studies. A huge monumental effort that was underway in some of the earliest lawsuits that were brought were in relation to monitoring and reporting and impact assessment. So we have a federal law that requires all public agencies to do robust review and monitoring of the impacts of their projects, any major projects. And so these were actions that require public or private entities to undertake more extensive monitoring, impact assessment, information disclosure related to greenhouse gas emissions, and describing how they were going to take climate adaptation into account. So, for example, there have been lots of efforts to require federal agencies to take sea level rise into account in any type of coastal development. There's been quite extensive litigation related to rights and liabilities. That has involved applying human rights, property rights, or civil rights law, and taking actions that provide protection of individual or the public at large against the effects or responses to climate change. So there have been cases that claim that greenhouse gas emissions have violated civil rights. So that's a bit of a very superficial overview of the types of actions that we're seeing in the US. And then I wanted to focus a bit on two specific case studies. I think many folks around the world and hopefully in Indonesia as well are really familiar with the JUliana v. US lawsuit. This was a lawsuit which in 2015, so going back several years, 21 youth and organizational plaintiff Earth Guardians filed a constitutional climate lawsuit called JUliana v. US against the United States government. And their complaint asserts that through the government's affirmative actions that cause climate change, it has violated the youngest generation's constitutional rights to life, liberty, and property, as well as failed to protect essential public trust resources. So this was a landmark case. There has been an incredible youth movement that has come to life as a result of this case. Unfortunately, it hasn't met enormous success in the court system thus far. It reached the Ninth Circuit, which is a federal appeals court in the US, and they determined that the remedy that the plaintiffs requested from the court, which was essentially comprehensive climate framework that would address both emissions reductions, mitigation, and the need to combat climate change adaptation, was beyond the scope of the courts, that this was an issue that needs to be addressed by our political branches, the executive and the legislature. So it was essentially the court's way of punting this issue over to the other two branches of government. However, this case is not over. The plaintiffs have asked, these 21 youth plaintiffs, have asked the court if they can amend their complaint, and the judge has ordered the parties to attempt to reach some kind of settlement. So that case is ongoing, and we will keep you all posted as it proceeds. There's another line of cases that I think will certainly be of interest as well, and these are the lawsuits brought by cities and states around the country against the major fossil fuel companies, BP, Chevron, Shell, ConocoPhillips, all of the big carbon majors. These lawsuits were initially brought by a handful of California cities and counties, seeking to hold the fossil fuel industry accountable for the lies and deception, the knowledge that they had that goes back to the late 50s, early 60s about the causes and consequences of climate change, and how they have lied and deceived the public since then, and for the damages they have caused as a result. This work is very much premised on the carbon majors research, and I would imagine you'll be discussing that at some point during your few days together. This was an incredible piece of attribution science which helped to identify the top carbon polluters and their contributions to historic carbon greenhouse gas emissions. This is, particularly relevant in Indonesia, I think, because Pertamina, hopefully I'm pronouncing that correctly, is one of the companies that was identified as one of the top emitters and producers. The lawsuits in the U.S. That have been brought against these carbon majors have been modeled after litigation brought against the tobacco and pharmaceutical companies for the harms their products caused. And these have been tremendously successful in the U.S. context. They've been brought under consumer fraud and misrepresentation for all of the false and deceptive and misleading information that these companies have put out into the public domain. They've also been brought under public nuisance and other common law tort claims, product liability claims, seeking damages to property, infrastructure, and harm to public health. We just received a very positive decision from the Supreme Court earlier this morning, so I'm happy to report that the Supreme Court declined to review one of the cases that was before them by the fossil fuel industry. So these cases will continue to proceed, and they've been in the pipeline, in the works for quite some time, and we'll see how they play out in state and federal courts. So all this to say is there's a lot of action in the U.S. There's a lot to learn from. Both the lessons learned are many. We've had many successes, but also many failures, and we're continuing to adapt our legal strategies as we go. And as I mentioned, I am very available and happy to support your efforts. If there are any questions that you have about my presentation or just U.S. climate litigation more generally, please feel free to reach out. I'm available at alyssa@climateintegrity.org. And I hope you all have a very successful meeting, and I wish you all the best.